Let's begin with a little history and constitutional background, because I think you need that in order to understand what the current rules of professional conduct are with regard to advertising and solicitation. Historically, it was considered improper to attempt to obtain clients by advertising and solicitation. And a clear statement of that is found in Canon 27 of the ABA's 1908 Canons of Ethics, which is on page 516 of the materials. And in Canon 27, the ABA stated that efforts to obtain business through circulars, advertisements, or personal contacts were unprofessional unless warranted by personal relations. So business was supposed to be obtained through personal relations, ideally through clubs or other kinds of contacts of that kind. However, beginning in the 1970s, there were a series of U.S. Supreme Court decisions declaring various rules of professional ethics unconstitutional under the First Amendment. And these decisions have radically transformed the advertising and solicitation area and have opened up all types of new marketing efforts for lawyers. We're going to be talking later on in today's class about internet advertising and the opportunities there. The first case in this area was the Bates case, which is discussed on pages 516 to 518 of the materials. That was decided in 1976. Bates was a case dealing with the price and availability of routine legal services. A couple of lawyers who had been employed by the Legal Services Program in Arizona decided to open up their own practice, and they decided that what they would do would be to try to provide routine legal services, name change, uncontested divorces, things of that kind at relatively modest fees. The Arizona bar authorities attempted to discipline them for their actions, claiming that this was a violation of the rules of conduct as they existed at that time. And the U.S. Supreme Court held that advertising of the price and availability of routine legal services was constitutionally protected and could not be prohibited by the state. In the Bates case, the court held that there were a number of restrictions and unanswered questions, so its holding was actually a quite narrow one. And if you look at pages 517 to 518, there's a discussion of various limitations on the court's holding. For example, the court said that its holding did not prevent the state from regulating false, deceptive, or misleading advertising. It said that advertising claims as to the quality of legal services were not addressed in the opinion. And there were others as well, but one I want to point out in particular is that the court said that special problems of advertising on the electronic broadcast media will warrant special consideration. And in fact, the Supreme Court has never decided a case on television advertising, so that remains a question as to whether special restrictions might be applicable in that situation. The next case in this line of cases was the RMJ case, and this, like the Bates case, was a case dealing with lawyer advertising. And let me pause for just a minute to draw the distinction between lawyer advertising and solicitation. Lawyer advertising is a communication that is broadly addressed to the community at large or to a broad section of the community. Solicitation, on the other hand, is in-person contact directed at a particular person. So they are really at poles from one another. There is another form of communication, direct mail advertising, which falls between those two, and we'll talk about that later on. But right now we're talking about the standards governing lawyer advertising. And the RMJ case, which was decided by the Supreme Court in 1982, dealt with more forms of advertising that were involved in Bates. In the RMJ case, the authorities in Missouri had established certain very specific guidelines that required lawyers, if they were going to advertise in accordance with these guidelines. And lawyers had to advertise using certain categories. There were particular restrictions on advertising. The RMJ case is significant in a couple of respects. One is the general standards that it announced for lawyer advertising. On page 518, the court said that there were three principles governing lawyer advertising. First, a state may constitutionally prohibit lawyers from engaging in false or inherently misleading advertising, or when experience has proven that in fact such advertising is subject to abuse. That latter category is not one that the court has yet employed, but it's one that they could employ in the future. But this first category basically deals with false or inherently misleading advertising. That can be prohibited. Secondly, advertising that is not potentially misleading may be regulated, but in a fashion that is no broader than reasonably necessary to prevent the deception. So that's potentially misleading advertising. So the first category is false or deceptive advertising, which can be prohibited. Second is potentially misleading advertising, which can be regulated but no broader than necessary. And finally, the third category is truthful advertising, which in some limited circumstances the state may regulate if it shows a substantial interest to support the regulation, and if the interest is in proportion to the regulation is in proportion to the interest served. In the RMJ case, just to take an example of the application of these principles, the lawyer in that case had advertised that he was a member of the U.S. Supreme Court, admitted to the bar of the U.S. Supreme Court. And the disciplinary authorities in Missouri went after him, saying that was misleading because it implied a very high level of competency and proficiency. The Supreme Court declared that this was potentially misleading advertising, falling into the second category, but that it was the regulation of it could be no broader than a disclaimer that would say something like admitted to the Supreme Court but no guarantee of any particular level of competency or proficiency. So Bates and RMJ are two basic cases on lawyer advertising, and basically establish constitutional protection for truthful advertising and also establish some limits as set forth in the RMJ case. Turning now to solicitation, where we have in-person contact. The two basic cases in this area are the Oralic case and the Primus case on pages 519 and 520. Oralic was a classic ambulance chasing case. And by the way, we're on page 5 of the slides. In that case, the lawyer had had personal contact with the prospective clients, one at that client's home and another in the hospital. The Supreme Court held that rules prohibiting in-person solicitation were constitutional because solicitation is fundamentally different from advertising. The state has important interest in preventing abuses associated with solicitation. And among other interests that were involved were, first of all, the in-person nature of solicitation gave rise to the high potential of abuse, and because it took place in private rather than a public forum, as was the case of advertising, it would be very difficult to police solicitation. So the Oralic case stands for the proposition that in-person solicitation under circumstances where there is the possibility of abuse is subject to prohibition by the state. There is a category of solicitation, what has been referred to as benign solicitation, where there is not the potential for overreaching. You could imagine a case in which a lawyer personally solicits a very sophisticated client, where there is no real potential for overreaching. That may be subject to constitutional protection or some level of constitutional protection. It has not yet been addressed by the Supreme Court. The other significant solicitation case is the Primus case on page 520 of the materials. This case involved solicitation by a lawyer associated with the ACLU by letter to bring a civil rights action on behalf of individuals who had been subject to sterilization by their doctor as a condition for the doctor accepting payment under the Medicaid program. And in that case, the court held that the solicitation was entitled to constitutional protection. Where there was solicitation on behalf of a public interest organization, and where the primary motive was not commercial in nature, and here, although Primus had the opportunity to receive legal fees, the motive was not primarily in nature. In that case, the solicitation could only be prohibited if the state showed the actual evils that the solicitation rules are designed to prevent, actual overreaching. And in the facts of that case, there was no actual overreaching because Primus had engaged in the solicitation by letter. So we have cases on general advertising, cases on solicitation. Now I want to turn to other cases dealing with targeted advertising and direct mail advertising. This is on page 6 of the slides. The Zauderer case on page 523 deals with targeted advertising. This was a case in which newspaper ads were targeted to clients who had used IUDs, that is, birth control devices. The court in that case treated the advertising as advertising subject to the RMJ standards rather than solicitation as alleged by the state in that case. And in that case, the state of Ohio, which was the disciplining state in the Zauderer case, had claimed that because these advertisements were targeted at potential clients who had used a particular device, that it was really amounted to solicitation through the newspapers. The courts rejected that. The court found that newspaper communications didn't involve the potential of overreaching, were possible to police, and therefore did not involve the evils associated with solicitation. They were therefore subject to the advertising rules. And the state failed to show that it had an important interest in the regulation of newspaper illustrations. The Shapiro case on page 523, which arose out of Kentucky, page 524, which arose out of Kentucky, was a case of direct mail advertising in which the lawyer wrote to individuals who were the subject of mortgage foreclosures and indicated that the lawyer could help prevent those foreclosures from taking place. The lawyer didn't mention that what he had in mind was bankruptcy proceedings, but in fact that's what was involved. In that case, the court held that the direct mail advertising was advertising, could not be prohibited, but could be regulated in some appropriate fashion. And in particular, the court indicated that the state could require the mailings be labeled as advertising material. The final constitutional case that I want to mention is the Florida Bar versus Wentford case, which is discussed on page 531 of the materials. That was a case in which Florida enacted a rule prohibiting direct mail solicitation or advertising of accident victims within 30 days after an accident. So while the Shapiro case had upheld the constitutionality of direct mail advertising, the Florida Bar versus Wentford case dealt with a restriction on direct mail advertising of accident victims and their families within the 30-day period after an accident. The court distinguished the Shapiro case, held that there was a greater interest of the state in preventing invasions of privacy of victims and their family members. The state also had a significant interest in protecting the reputations of lawyers. And it indicated that lawyers could still inform prospective clients of their need to act promptly through the advertising medium. So these cases constitute the constitutional framework which are the foundation of the rules of professional conduct. That is, in drafting the rules of professional conduct, the drafters have been careful to draft the rules to be consistent with the case law dealing with First Amendment protection of advertising and solicitation. There is considerable variation in the state rules from the model rules. This is one area in which the degree of variation is quite great. And the South Carolina rules in particular vary considerably from the model rules. Obviously, in practice, you must follow the state rules that are in effect with regard to your advertisements. Typically, the state rules adopt the ABA principles, but then add various restrictions. For example, under South Carolina Rule of Professional Conduct 7.1e, this is an addition to the rules in South Carolina, it is improper for a lawyer to use an advertisement that implies an ability to achieve results, like the heavy hitter with a quote, strong arm. You don't find this directly in the ABA rules, but it is found in the South Carolina rules. Going through the rules, and we're dealing here with rules 7.1 through 7.5, the basic principle with regard to all forms of communication, whether through the media, in person, by letter, whatever, is found in Rule 7.1. That rule basically prohibits any form of professional communication that is false or misleading. The comments talk about various forms of communication that might be false or misleading. Comment 3 speaks about results obtained advertisements, for example, ones that deal with the verdicts obtained on behalf of clients. Advertisements that compare the lawyer's services with those of other lawyers are also mentioned in comment 3. Both results obtained advertising and unsubstantiated comparisons can create misleading expectations on behalf of clients. Comment 3 indicates that an appropriate disclaimer may prevent a client from being misled. Rule 7.2 deals specifically with advertising. And as we've said, advertising is a form of communication aimed at the public or a segment of the public at large rather than particular individuals. Rule 7.2 is subject to Rule 7.1, the General Communication Rule, and it's also subject to some provisions of Rule 7.3 dealing with direct contact with prospective clients. Rule 7.2 prohibits the giving of anything of value for recommending the lawyer's services, subject to certain exceptions. One of these exceptions that we'll talk about later on deals with referral services. 7.2c indicates that any advertisement under Rule 7.2 shall include the name and office address of at least one lawyer or law firm responsible for the content of the advertisement. There are other specific rules that can be included and have been included in some states. For example, the Zauderer case stated that any advertisement about the lawyer's fees must indicate whether the client is responsible for any expenses in connection with the case. And South Carolina Rule of Professional Conduct 7.2f picks up that requirement of disclosure of the obligation to pay expenses. .2f in South Carolina says, every advertisement that contains information about the lawyer's fee shall disclose whether the client will be liable for any expenses in addition to the fee, and if the fee will be a percentage of the recovery, whether the percentage will be computed before or after deducting the expenses. Rule 7.3 deals with in-person solicitation, as in the O'Wallett case. 7.3a prohibits in-person solicitation, whether in person, by live telephone contact, or real-time electronic contact. So a lawyer acting in a chat room to solicit professional employment would be violating Rule 7.3a. The rule does not apply except when a significant motive for the lawyer's doing so is the lawyer's pecuniary gain. So solicitation to render services for free would not be subject to Rule 7.3a. It could be subject to Rule 7.3b2, which prohibits solicitation that involves coercion, duress, or harassment. The prohibition on solicitation found in 7.3 is subject to several exceptions. One is if the recipient of the solicitation is a lawyer. That is exempt from the prohibition on solicitation. Secondly, if the person has a family, close personal, or prior professional relationship with a lawyer, then the solicitation is proper. So you are free to solicit prior clients to see whether they need your firm's services in new matters that you are representing clients with regard. Even if a solicitation is permitted under 7.3a, it is prohibited if it involves solicitation involving coercion, duress, or harassment. That's in 7.3b2. Direct mail solicitation, as in the Shapiro case, is permitted, as the court held in Shapiro, but subject to regulation. Under the ABA model rules, it must be identified as advertising material. Regulation in other states may require filing of direct mail solicitation material and may require other warnings. So South Carolina has those requirements. South Carolina also has various other notice and filing rules that are applicable to direct mail solicitations. Communication of fields of practice and of specialization are covered by Rule 7.4. The rules allow a lawyer to advertise that the lawyer practices in certain areas or limits his practice to certain areas, even if he is not a certified specialist in that area. Patent and admiralty law are traditional areas of specialization recognized by Rule 7.4b. If the state has a specialization certification system, as South Carolina has in certain areas, a lawyer cannot advertise the specialization if he is not certified, as set forth in 7.4d. There is an exception to this for advertising by national organizations or certification by national organizations, as in the Peel case, 519. So Rule 7.4 doesn't cover everything, but it does indicate some restrictions on the matters that it does cover. Rule 7.5 deals with firm names and letterheads. And first of all, 7.5 states that a lawyer cannot use a firm name or letterhead or other professional designation that is false or misleading under Rule 7.1. It also states that a lawyer's name should not imply a connection with a governmental agency or with a public or charitable legal services organization. And the South Carolina Ethics Committee had to deal with some firm names that dealt with, they were like Capital City Associates, Palmetto Associates, and the question was whether these geographical designations indicated an affiliation with the government. And the committee found that they did not, that they were mere geographical designations. But if it indicated something that was an affiliation with the government, like Charleston Legal Services or something like that, that would be improper under 7.5a because it would be a trade name that would be misleading. But the use of a trade name is permissible under Rule 7.5a. Rule 7.5b deals with multi-jurisdictional firms. It allows a firm to use a name in many jurisdictions. It also indicates that if the names of lawyers are indicated on the letterhead of the firm, it must indicate the jurisdictional limitations of those lawyers. So, for example, a firm in, let's say, Rock Hill that had lawyers practicing in North Carolina and lawyers practicing in South Carolina. If the letterhead identified those lawyers, then it would be necessary to indicate their jurisdictional limitations, that is, the states in which they practice and the states in which they're not admitted to practice. 7.5c says that a lawyer holding public office shall not be, the name of such a lawyer shall not be used in a law firm during any substantial period of time in which the lawyer is not actively and regularly practicing law with the firm. So a lawyer who was in a firm who was elected to Congress or the U.S. Senate, that lawyer's name could no longer be in the firm. But if they were elected to the South Carolina legislature, then they could be, because they would be actively involved in the practice of law during that period of time in which they're in the legislature. 7.5d indicates that the name of a firm must not imply a relationship or a partnership that does not exist. So, for example, if lawyers have nothing more than an office-sharing arrangement, they couldn't use their names jointly together without violating Rule 7.5d. All right, that brings us over to slide 15, which gets us into the problem 7-1. And this problem deals with the law firm of Manelli and O'Hara, and this law firm has adopted several different marketing techniques. We want to take a look at the ethical propriety of these different marketing techniques. It's a plaintiff's personal injury firm, a fairly aggressive firm, and they're running a series of television advertisements. The advertisement begins with a lawyer from Manelli and O'Hara sitting on a desk in shirt sleeves, saying the following: if you've been injured in an accident or while at work, we at Manelli and O'Hara are available to meet with you to discuss your legal rights. There is no charge for an initial visit, and no fees are due unless we secure a recovery on your behalf. And then there are 3 different segments that can be used in the advertisements. The first of these is as follows: at Manelli and O'Hara, we work tirelessly to satisfy our clients and achieve favorable results. We survey our clients on completion of our cases. More than 95% of our clients are extremely satisfied or very satisfied with our work. Members of our firm have obtained more than 50 settlements and judgments in excess of $100,000. So broadly speaking, what this deals with is the propriety of advertisements that focus on the results that a lawyer obtains on behalf of a client, and in particular whether any form of results obtained advertisement may be considered to be ethically improper. The general rule is 7.1, which states that you cannot have a false or misleading advertisement. More specifically, comment 3 to Rule 7.1 states, an advertisement that truthfully reports a lawyer's achievements on behalf of clients or former clients may be misleading if presented so as to lead a reasonable person to form an unjustified expectation that the same results could be obtained for other clients in similar matters without reference to the specific factual and legal circumstances of each client's case. So an advertisement about simply the results obtained, where you were talking about 50 settlements and judgments in excess of $100,000, could lead to an unjustified expectation on behalf of a client that similar results could be obtained. There are 2 ways of dealing with this. One is simply to forego any such advertisements. The other is through the insertion of an appropriate disclaimer, which probably will cure the problem. Not conclusively, but probably. Comment 3 to Rule 7.1 says the inclusion of an appropriate disclaimer or qualifying language may preclude a finding that a statement is likely to create unjustified expectations or otherwise mislead a prospective client. So what must the firm do? Well, first of all, we have a number of different results obtained statements here. One is about surveys of the clients and that 95% are satisfied. First and foremost, if a firm is going to advertise about results obtained, the advertisements it makes must be truthful. If the firm says it surveys, it must surveys. If it says 95% of the clients are satisfied, that must be accurate. So that's the first thing that the firm must do. With regard to specific statements about settlements or judgments, I think it's necessary to include an appropriate disclaimer to avoid the charge of unjustified expectations. Here's an example of what a disclaimer might look like. Nothing in this advertisement should be construed as a guarantee of results in any matter in which Minnelli & O'Hara undertakes representation of a client. The outcome of a particular matter can depend on a variety of factors, including the specific factual and legal circumstances, the ability of opposing counsel, and often unexpected developments beyond the control of any client or attorney. That's on page 19 of the slides. Now, second one of the advertisements that's run by Minnelli & O'Hara, number 2, when you retain Minnelli & O'Hara, you're getting the quality representation of a large firm, but with personal treatment and for less expense. We have extensive experience in all types of litigation. Members of our firm have clerked for state court judges, served in the legislature, worked for the Workers' Compensation Commission. While most firms charge 1/3 or more to handle your case, we will represent you for a 25% fee. This is comparison advertising that compares the lawyer's services with the services of other lawyers. Comment 3 to Rule 7.1 states, similarly, an unsubstantiated comparison of the lawyer's services or fees with the services or fees of other lawyers may be misleading if presented with such specificity as would lead a reasonable person to conclude the comparison can be substantiated. So it's necessary to be able to substantiate the statements in question. In this case, the statement is you're getting the quality representation of a large firm, but with personal treatment and for less expense. Those must be substantiated. If they can't be, they should be eliminated. And in addition, it would be appropriate to include, and perhaps even necessary to include, an appropriate disclaimer, such as, this communication is not intended as a comparison of the services offered by the firm with the services of other lawyers. Of course, if in fact you're doing that, then such a general statement may be of little effect. Segment number 3, at Minnelli & O'Hara, we provide financial help when you most need it. If your case is one of clear liability, we can help you get money within 60 days. First problem here is it's improper to advertise results by means that violate rules of professional conduct or other law. And you can see that in comment 4 to Rule 7.1. That raises the question of how is this money paid? If the money is paid by a lawyer, it undoubtedly violates Rule 1.8e. This is a rule we looked at before, which says that a lawyer cannot provide financial assistance to a client in connection with pending or contemplated litigation, except, in essence, the expenses of litigation. This would not be an expense of litigation. It would be a loan to a client based upon the prospects of the case. That would violate Rule 1.5e. If it was a third-party financing company, and there are quite a number of these days in the litigation industry, depends on the legality of such a company. In some jurisdictions, third-party financing may be improper under Champerty or other rules, but in many jurisdictions it may be proper. You might want to look at the material on pages 89 or 90. Another issue that's raised by rule or by problem 7.1 is the direct mail solicitation of accident victims. The firm has acquired the name and address of accident victims from the police department, and it's going to send letters to individuals involved informing them of the firm's availability to consult with them about their legal matter. And one issue is how the firm got this list and whether or not it was done in compliance with law. If it was done in violation of law, then it would be improper to attempt to have mailings to these individuals. Even if it was in compliance with law, under Rule 7.3c, which deals with direct mail solicitation, there must be a disclosure that this is, quote, advertising material, close quote, at the beginning and ending of any advertisement. The Whitford case, of course, upheld the constitutionality of restrictions on direct mail solicitation, so a state may permissibly include the advertising material disclosure and may have a filing requirement, may have other requirements as well. In evaluating the advertisements of Minnelli and O'Hara, you would have to look to see whether there were other aspects of the advertisement that might be improper. This advertisement does not disclose the client's liability for any expenses, whether or not there is a recovery. That could be misleading under the Zauderer case. Some states have specific rules to that effect. South Carolina is one of them. South Carolina Rule 7.2F states, every advertisement that contains information about the lawyer's fee shall disclose whether the client will be liable for any expenses in addition to the fee. And if the fee will be a percentage of the recovery, whether the percentage will be computed before deducting the expenses. Another issue deals with the firm's telephone number, which is 1-800-MONEY-NOW. That could be viewed potentially as false or misleading, although it's hard to believe that any reasonable person would be misled by such a telephone number. It could also be viewed as undignified because it focuses on getting money rather than the merits of the case. However, the comments indicate in comment 3 to Rule 7.2 that dignified or the dignity of the advertisement is not something that is covered by the rules. Comment 3 to Rule 7.2 says, questions of effectiveness and taste in advertising are matters of speculation and subjective judgment. Some jurisdictions have had extensive prohibitions against television advertising, against advertising going beyond specified facts about a lawyer, or against undignified advertising. Part B of problem 7.1 deals with marketing practices. And there are a number of marketing practices that law firms can engage in. Seven 7.1 gives you 8 of these. And these raise various issues of professional conduct. For example, take the news release as a method of advertising. First of all, anything that's said in the news release must be truthful. If it refers to success, you would have to deal with the problem of advertising about results obtained, and would have to probably include an appropriate disclaimer. To the extent the news release related to pending litigation, it would have to comply with Rule 3.6 dealing with pretrial publicity. If you're dealing with cross-marketing, what you're talking about is if you have clients who have existing legal representation by the firm, offering to provide to them legal services in areas where the firm does not currently represent them. So for example, if you had a corporate client and then you started doing trademark or intellectual property work, to offer to that client to do that type of work. It is a form of solicitation, but permissible solicitation under Rule 7.3A2 because it is of an existing client. That's an important exception to the prohibition against solicitation. You can solicit from your existing clients. A brochure or a newsletter, these of course would have to be truthful. One issue would be to whom they are sent. If they are sent to people who are not existing clients, then you have the problem of it possibly being a solicitation, although it's more likely to be viewed as general advertising. Sent to existing clients, no problem, because you could even solicit existing clients. If the brochure or newsletter relates to a specific legal problem in which the recipient needs legal advice, then that may be treated as direct mail solicitation that would have to be labeled as advertising material. Skipping down with regard to marketing practices, aggressive entertainment policies where you take clients out for various forms of entertainment, maybe even trips or things of that kind. A couple of points here. If you're dealing with a governmental client, there may be Ethics in Government Act which would prohibit any such entertainment. If you're dealing with a private client, there may be internal policies of that private client that would prohibit or restrict entertainment. Let's turn now to Part C, which deals with marketing through website and other forms of technology. What are some of the issues that might arise with regard to website marketing? Well, first and foremost, there is the requirement that any advertisement, whether on the internet or otherwise, cannot be false, fraudulent, or misleading. ABA Opinion 10-457 on page 526 is an important recent opinion dealing with this topic, and one that allows the or warns lawyers about the need to be truthful in their website advertising. Secondly, we have mentioned the concept of the prospective attorney-client relationship, where a client seeks advice from a lawyer or seeks the possibility of forming an attorney-client relationship, in which case Rule 1.18 becomes involved, and the lawyer personally may be disqualified from handling the representation of an adverse party. So lawyers in doing internet communications must be aware that they may create a prospective relationship under Rule 1.18. Since the internet is accessible anywhere, internet ads must avoid unauthorized practice problems. And the way to do this is disclaiming the offering of services in jurisdictions where lawyers are not admitted to practice. Now, if the law firm has affiliate relationships with those jurisdictions, then that could be indicated on the firm's website. If a lawyer participates in real-time communications, chat room or things of that kind, then you have the problem of in-person solicitation regulated by Rule 7.3. It would be wise for lawyers to refrain from such forms of communication because of the potential problem under Rule 7.3. We've already talked about results obtained advertising and comparative advertising with the lawyers. Those are both regulated by Rule 7.1. In addition to that, there are other forms of advertisement that may be questionable. Testimonials, for example. For many years, the ethics rules prohibited testimonials. They don't seem to do so now, although in South Carolina, we have a non-uniform provision dealing with testimonials, which allow testimonials under some circumstances, but with restrictions. This is Rule 7.1D. And finally, with regard to website marketing, in jurisdictions where the advertisement is intended to solicit clients, the advertisement is going to need to deal with those local rules and whatever peculiarities of those local rules there are. For example, in South Carolina, you can't say you're an expert or a specialist unless you've been certified by an appropriate agency. And so you have to refrain from those words. With regard to social networking sites such as LinkedIn or Twitter, these are widely used these days to market legal services. First of all, not all social networking sites are subject to the rules of professional conduct. If I have a private Facebook page and I use that simply for friends and family and only mention legal services in passing, for example, just about what I do, that would, in my opinion, not be subject to the rules of professional conduct. However, professional sites such as LinkedIn and Facebook, if it's used for business purposes, certainly do involve the practice of the law, and there are restrictions on the use of those sites in order to comply with the ethics rules. Assuming the site is for advertising purposes, the lawyer must comply with the rules applicable to website advertisements. So assuming that the social networking site is one that's used for advertising purposes, like LinkedIn or like Twitter, to deal with professional activities, then you're going to have to comply with the rules applicable to website advertisements. So, and this can be particularly difficult for Twitter because it's so short in nature, although I suppose you can have a link in your tweet that would refer to various disclaimers and other material on your website in order to comply with those obligations. There are other problems that arise with regard to social networking sites. You've got to be careful not to violate client confidentiality with regard to any posts. And in the casebook on page 528, there's reference to some cases in which lawyers have been disciplined for revealing confidential information either on their blogs or their websites, or in this case would be on the social networking sites. Posts about pending cases may violate Rule 3.6 dealing with trial publicity, so you have to be cognizant of the restrictions of that rule as well. A third area of internet advertising deals with referral sites. The applicable rule with regard to referral sites is Rule 7.2B2. (7.2B) first of all says that a lawyer shall not give anything of value to a person for recommending the lawyer's services. So basically, if you're paying someone to recommend your services, that's prohibited unless it falls within one of the exceptions. One of the exceptions is pay the reasonable cost of advertisements and communications permitted by this rule. And then if you look at the comments under the rule, it has various forms of payment which are permitted. The B1 exception allows a lawyer to pay for advertising and communications, including print directory listings, online directory listings, newspaper ads, television and radio airtime, domain name registration, sponsorship fees, banner ads, and so on. So a lot of that would be permitted under 7.2B1. There are on the internet a number of referral services or services that link lawyers and clients. And the problem here is, does a payment to such a service, whether by click or however, Does that constitute a reasonable cost of advertisement, which is permitted under 7.2b1, or is it an impermissible payment to a for-profit referral service, which is not allowed under 7.2b2? So it raises the question of how you draw the distinction between advertising advertising versus a referral service. New Jersey Opinion 43, which is in the materials, deals with this issue. And it specifies 3 factors for determining whether a site is an impermissible referral site. First of all, is access by lawyers to participation in the site limited? If the site is open, like a telephone directory or other kind of directory, that indicates that it's advertising rather than a referral site. Does the site guide consumers to a specific area? In particular, are areas allocated to lawyers based upon the payment of fee, in which case it's going to be treated as a referral site. Whether the marketer is primarily serving a public purpose rather than commercial purpose. If it's a site that's set up by a nonprofit organization for the purpose of providing legal services, that's one thing, but if it's a site that's trying to make money, that's another thing. Even if these requirements are not met, a site will still be treated as a permissible advertising site if it, this under the New Jersey opinion, if it fully discloses information to prevent misleading consumers, and in particular how attorneys are selected for participation in the site and how matters are referred to them. So that New Jersey opinion is an important recent one dealing with referral sites and when participation is proper and when it is not. With regard to these matching sites, you cannot divide legal fees. So it would be impermissible to have an agreement in which the firm said, we'll pay you 10% of any fees generated from this site. You can have fees based per click or some flat fee. You could also have a fee that would be based upon the readership of the site, much like fees that are paid to newspapers or to television is based upon their readership or their market share. But you can't split fees. You can't have any interference with independent professional judgment of the lawyer by the site.